Edgar J. Hooves said, and I quote, "Justice is merely incidental to law and order." Think about that. I say a warm welcome to the Law Gallery, coming to you from the Lagos studios of KAFTAN TV. Khalid, Bada is my name. And as you know, I always have interesting packages lined up for your pleasure every week. And just like that, I already have packages for you this week too, which will be starting with the news updates on the program today. So sit tight as we bring you the news updates. We'll be right back.
Hello and thank you for joining us on the news update of the program, The Law Gallery. I am Omotoshola Shari-Makin. We begin the news as the president of the Nigerian Bar Association (NBA), Mr. Yakubu Chinoko Mayakao, OON SAN, has stated that the fight against money laundering and terrorism financing is a legal fight that must be fought within the framework of extant legislation, and that there is no profession better positioned to be at the vanguard of the fight than the legal profession. Mr. Mayakao made this remark in Abuja while attending the ongoing national AML-CFT-CPF compliance retreat being organized by the Nigerian Financial Intelligence Unit, NFIU. It will be recalled that the NBA president, in a recent notice to lawyers, has insisted that the NBA will self-regulate its members with regard to money laundering and terrorism financing concerns, but that the NBA will not allow or in any way subscribe to any arrangement or that the subject of the legal profession to the regulatory control of the third parties. Therefore, while imitating the retreat of the passage of the Rules of Professional Conduct (RPC) for the Legal Practitioners 2023, the president further noted that in recognition of the dangers of money laundering and terrorism financing on the integrity of the legal profession, the NBA has ensured that the Part 2 of the new rules incorporate guidelines and rules of anti-money laundering and combating financing of terrorism for legal practitioners. He further noted that the new rules will come into effect on the 1st of January 2024 to allow time for sensitization, advocacy, and setting up of necessary structures for implementation of the guidelines. In the meantime, a spokesperson has said that President Bada Tinubu has not approved any salary increases for political and legal officials. The presidential spokesperson, Dele Alake, responded to a statement purported to come from a Revenue Mobilization Allocation and Finance Commission (RMAFC) official, saying a 114% salary increase for politicians, civil servants has been approved. Alake did not object to the RMAFC making such a proposal, but said it would not go into effect without the president's approval. Many Nigerians have also criticized the proposal at a time when government policies such as the abolishment of fuel subsidies have prompted the public to prepare for rising prices of goods and services. And finally, on the news on Law Gallery, the Labour Party presidential candidate Peter Obi criticized on Thursday that the Revenue Mobilization Allocation and Finance Commission (RMAFC) is proposing a 140% increase in the salaries of elected politicians, including the president, vice president, governors, and lawmakers. The RMAFC has heavily criticized for recommending an increase in the base salaries of the country's public officials. The Kebbi RMAFC chairman Muhammadu Shekib, represented by Mrs. Rakiya Tanko Ayuba, a member of the Kebbi RMAFC Commission, unveiled the proposal on Tuesday in the political capital, Kebbi, at the same time as the governor's political and judicial remuneration package, presented at a revised version. Nasir Idris. In a Twitter post, Obi called the recommendation insensitive, saying more than 833 million Nigerians now live in extreme poverty and are still struggling to meet the minimum wage. He warned that the recommendation should not be priority for countries struggling. And that's it on the news update for today. We'll go on a short break now to return to Khalid for his discussion. I remain Omotoshola Shari-Makin. Bye for now.
Welcome back to the program. It's still the Law Gallery coming to you from the Lagos studios of KAFTAN Television. Now, this is where we get to bring in our brilliant legal practitioners who will be doing justice to basic concepts and questions that we have surrounding the rule of law, the Nigerian rule of law, the practice of law in Nigeria. And today we'll be talking about criminal law in Nigeria. Now, we are joined by a brilliant practitioner, person of Barrister Busayo, Adetunji. Now, before we go into the discussion, briefly, criminal law, as distinguished from civil law, is a system of law concerned with crimes and the punishment of individuals who commit crime. Thus, wherein a civil case, two parties dispute their rights, a criminal prosecution involves the government deciding whether to punish an individual for either an act or an omission. Well, thank you for joining us today on the program, Barrister Busayo.
Thank you, Sue. Thank you for having me.
Glad to have you on the program. Now, let's just go into the discussion proper. What are the key components, the key concepts of the law, the criminal law in Nigeria?
Okay. First thing first is that the concept of criminal law is broad.
Okay.
In the sense that when one reports a crime or informs the police about the crime, that person that does the information wants justice.
Sure.
And on the other hand, there is an offender.
Sure.
And there is that offender also wants justice, so to say, in the sense that we never can tell if the offender actually committed the crime.
Okay, okay.
So in that wise, the offender would actually want justice for him or her, for him or herself. All right, so the concept of criminal justice, like I said, is broad. We will start by saying, okay, there is an information already about a crime that has happened. And thereafter, we want to know what caused that crime. We want to know what caused the offense or what led to it. And then the person or the people or the agency involved with that initial stage of when the information was relayed or laid to them rather is the police. Now the police takes it up from there and they do the needful in the sense that the offender, so to say, is maybe invited to the station for interrogation or for questioning so that they can take up the matter, they can know what next to do concerning that case or concerning the information. So as of when the person is being invited to the police station, the person has the right, has a lot of rights. That's the offender now, the suspects has a lot of rights at that instance. So, but first thing first, when the police has questioned this person or when the police is interrogating this person is liable to bail. Now, you know, police will say police bail is free and all of that stuff. But, you know, the reverse is the case when it comes to our Nigerian system.
What do you think is the major contribution to the fact that bail in Nigeria is not free? Is it constitutional, or is it just something the Nigerian police force decided to just leverage on? Okay, the fact that maybe there isn't an institution checking their activities. I'm just finding it confusing.
Well, the constitution is the ground norm of the law, of the land rather.
Yes.
It's the ground law of the country. And any other law that is contrary to what the constitution has provided would be void, is void. Now, there are other laws stipulated for other agencies. You remember we have a constitution already that is guiding the country already. But the police also have their laws. They have their acts. But that does not mean that the act provides that bail is not free.
Okay.
Even when you go to the police station, they have these posts where they say bail is free.
Police is your friend.
Yeah, police is your friend. So we all already have that knowledge of the fact that, oh, when they arrest someone that is at the police custody and the person is, you know, granted bail, the bail is free. You're not to pay any sum or whatsoever while they grant the person bail. But like I said, the reverse is the case. The Constitution provided that bail is free at the police station. Even the Police Act also, bail is also free. But you know, things happens, and there are a lot of things that can actually come into play that we don't know about. It actually happens behind the scene, so to say. So we hear stories where they will say bail is free, but at the end run, at the long run,
it is not
it is not free. I happen to actually have an experience with the police as when I started practicing the early stage then. So I went to the police custody, and they were like, okay, so they granted the accused or the suspect bail of so and so amount. And I was like, oh, okay, fine, since bail is free, if the person jumps bail, then the person will be liable to pay that amount. So let's free him, let him go, let us just fill the required form and all of that stuff. They laughed at me. They were like, am I Johnny just come? Don't I know what is going on? And we just had to start negotiating the amount to pay until we finally resolved it.
Now, is it that actually I don't have a personal experience of paying bill or probably seeing a situation where bail is being paid? Now, is it that the Nigerian police force or officers of the Nigerian police have different amounts for different offenses? Probably somebody that stole a phone, 2,000 naira. Somebody that did this, 5,000. Is it that, or is it just they're just speaking out of their discretion?
The first thing for us is that it's not all offenses that are bailable.
Okay.
Yeah. So there are minor offenses that are bailable, while capital offenses are not bailable. So the suspect or the accused person involved in capital offenses such as murder, kidnapping, rape, defilement, they don't grant them bail. Because if they grant such persons bail, they are likely to actually commit that crime. Abscond is part of it, and also likely to commit that crime in the long run, or even try to affect investigation processes. So that is why they don't they don't grant them bail. But for minor offenses such as say breach of peace or stealing and the likes, they grant such people bail. And they should have an amount, but it's not like they have a static amount of so say stealing, for instance. Now stealing doesn't have a certain amount of money that is for bail, but I think they should have a range that within so amount to this amount is what they can actually say this is the bail sum for that person.
Now, just out of curiosity, I would like to ask you, is there certain things that people don't actually pay attention to that are actually criminal acts, but perhaps just loitering the streets? One might consider it to be, okay, this is not a criminal act, I only just threw the nylon here, and I just want to know out of curiosity.
Okay, so ignorance of the law is not an excuse, and that is why I would always say that irrespective of the fact that the constitution is there, like it provides for different lot of things, it's guiding the country, is guiding the people. It has provided say laws and some other things that are needed to be known. So we should not just say because of it is constitution or because of it is an act, it is boring, I don't want to read it. We can just Google up on things. But Nigeria has actually laid something like a leverage for people to do a lot of things, a lot of atrocities, and they don't want to even know if it is a crime or an offense. They just want to, whatever, it is the country that has caused me to react this way, the country that has actually made me to feel this way. So there was a matter I went for. I think the first case that I handled, it was for breach of peace. The offense was breach of peace. So this man was actually beating his wife and stuff like that, and he was causing some things, like in the area, disturbing the peace of the neighborhood. So it was those people around that reported him to the police station. Him torturing his wife, it's not right morally and even legally. It's not something that should be, it's not something that should actually be condoned, and maybe he didn't know that it was an offense. Maybe because he thinks this is my wife now, she's my wife, so I can like to do whatever that I want to do to her. And like I said, he didn't know that it can be an offense. So he kept on doing that until the neighborhood went to report him. And he landed him at the police station. He didn't stop at the police station. He actually landed him at the prison. So
Wow.
this is something that should actually be resolved within the police station. I mean, beating your wife is a bad thing. It's not a good thing. But then it's something that can be resolved amicably within that space. Not even now. He actually spent close to 2 years for that. His wife was not appearing in court and all of that.
You know, talking about disturbance of peace, you made a point, you spelled out an example where a man was battering his wife and, you know, neighbors reported and it was actually taken up. What of the religious institutions? The churches, the mosques, they wake up in the morning, the microphone is everywhere. That is obviously disturbance of peace. And I'm sure people might have one time or the other reported such situation. Is that considered to be under the criminal law or probably just a breach of human rights, or I don't know where to categorize that?
Okay, I wouldn't say it should be categorized under the criminal law.
Okay.
Because for every matter that is being reported, you know, it's supposed to be open to settlement. There is supposed to be this agreement between the two parties where they sit down and resolve things amicably. Oh, this is what we don't like. Oh, okay, since you don't like this, let us make amends, or we'll make amends concerning it. So as regards that, I wouldn't, you know, categorize it under criminal law. And I wanted to also say that, you know, the Constitution provides that everyone has a freedom of religion. So you have that right to, you know, worship anything or anybody you want to worship. But you shouldn't use that to disturb the next person beside you. So if such an issue comes into place, I would say it's something that should be resolved amicably. It's not, well, I know how, I don't want to say, yeah, yes, like, you know, the noise, and especially early in the morning when some churches or maybe the mosques have this program or service early in the morning and you are living next to the church or the mosque, it disturbs your sleep and all of that stuff. So I understand that fact, but I know, or I think that people are open to settlement. So when you come, you meet these people or you meet this person and you, you know, you report such things to that person, I think they should be open to.
Yeah, thank you very much for pointing that out. Now, how does the criminal justice system work in Nigeria? From the step of probably reporting a crime to the stage of giving a sentence, how does it work? What are the steps?
Okay, first thing first, if someone has, you know, been, maybe a person's right has been infringed on, let me put it that way, or say there's a report of a crime. Now, the victim goes to the police station, writes a petition against the offender, against the accused, and, you know, they send it to the police station. Now, the police takes it up from there. So when a petition is written against an offender, the police would invite such person to the station for questioning, like I said earlier. So this person is questioned on that position, the offense or the crime that person that has been alleged that the person committed. Now, when this offender is not you know, settled on the fact that he or she committed a crime, the police can take it up to the courts. Now, at the police station, first of all, while they are questioning and interrogating and all, if the police want to take up the matter to court, that person in the police custody with them is not meant to be detained after 2 days. I don't know if you get what I'm trying to say, in the sense that
48 hours.
Yeah, 48 hours. Now, the maximum is 48 hours if the court is far from where the police custody is. Now, at that stage, this person is also liable to bail.
Okay.
Police bail now, because the person is still within the police custody. But it depends on the nature of the offense, like I said earlier. So if it is a capital offense, for instance, the person won't be granted bail. But if it's a minor offense, the person will be granted bail. And it is now left for that person to perfect the bail at the police custody, at the police station. But if the person is not able to perfect his bail, and they now, take up the matter to courts, they profile a charge in court against that person, and the person is now arraigned in court, the person has forfeited the police bail. The police bail is done, over. Now, when the person is arraigned in court on any day, it is the duty of the person's lawyer to ask the court for bail for that person, for the suspect, the accused. And when the person is able to perfect it, it's fine. If the person is not able to perfect it, the person will be remanded in the prison, in any of the correctional facilities. So from the police station to the court to the prison. So now, while the person is at the prison, there are a lot of things that are supposed to be happening in that person's case in courts. And that is where trial proceedings come into place. So the person that writes or that wrote the petition against the accused is meant to be in court at all times when the case is being called in court. But if the person doesn't come, they call that person the complainant. So if it doesn't come to court, then say for a while, say after 5 to 6 adjournment, it depends on the magistrate or the court or the judge sitting over the matter. If the person doesn't come to court, the magistrate or the judge can strike out the matter because the complainant is not serious. Okay. It doesn't show seriousness to wanting to get justice for that offense. So, but if the complainant is, coming regularly to court, this matter would be taken up to trial proceedings. At trial proceedings, the complainant will give evidence as to how this person has actually committed that crime against him or her. Now, the law is not just one-sided. Okay. It is for both parties. When the complainant gives his evidence, the defendant also, that is the suspect or the accused person, also gives his evidence. That, just to show that there is fairness in all of it, it's a fair trial. It's not just for the complainant alone because it's the person that brought the matter to court. No, the defendant should also be heard at that instance. So the defendant also gives his testimony, and also when the court takes the two evidence, records it, then it goes for judgment.
Now, what can be considered as evidence? Is it just pictorial or audiovisual or audio?
Yeah, it could be pictorial, it could be video, audio, anything.
Anything can be considered as evidence.
Yeah, so far it is going to be relevant for that case, for that particular case. If it is relevant, then it can be admitted.
Thank you very much for the clarification. Now, the Nigerian judicial system, does it have an arrangement, perhaps a special arrangement for persons living with disability or probably underage? Are they treated differently, or the process is just the same for everybody?
Okay, now I just want to ask if what you're trying to say is these persons under age or with disabilities are...
Persons living with disability at one side. Perhaps, maybe I should break it into two.
Are they offenders now? Or
yeah,
what?
Offenders.
Okay.
Offenders. Person living with disability as an offender and an underage as an offender. Is there a different way? Is there a different approach the judicial system has to address their case?
Yes, there are different approach to persons living, persons underage now. Okay. So now, say persons under 18 years of age. They're not yet 18 years. They are not to be taken to the correctional facilities where we have the female and the male people in it. These people are called the juveniles. So at the point where they are taken to court and arraigned and they are to be remanded, they are taken to the juvenile homes. So the juvenile homes ensures that they are being produced in court as at when they, call up their matter in court until they attain the age of 18. Yeah. So for persons with disabilities, living with disability, they are also not, to be regarded as those ones living with the male and female correctional facilities. They are also set aside.
Thank you very much for that. Now, What are some of the major challenges that are currently facing the Nigerian judicial system? Is it maybe underfunding or lack of enough practitioners, or maybe the jackpot factor is even affecting the judicial system in Nigeria right now?
Yeah, a lot of things are affecting the judiciary system in Nigeria. First of all, I will start with the police.
Okay.
Now, the police are the first point of contact for any crime or for any offense. But usually, we get to see that a lot of things happen right from police investigation. You see the loophole already. Do you know that there are some inmates in incarceration right now that were arrested for a crime they know nothing about? What are we going to say about that? Like, because we know that the police are the ones involved in investigating the matter, but are they trying to say that the police did not investigate this matter well? Like, I mean, the answer would be in the positive. Now, I think some things that happen is that the police needs to be trained.
Okay.
And they need to be retrained. So there are some, police with these lower ranks that we see on the road. Once they, stop someone, the way they will stop the person safe, the passerby will be wondering what's up, what's going on, what did I do?
Definitely.
And from there they'll be like, I want to see your phone, and they'll be like, what is my personal property and stuff like that. Before you know, they start torturing this person outside, they assault this person outside, just because they want to effect arrest on this person, which is not supposed to be so. It is until maybe when you find out that this person you want to arrest is armed, and you know that the person committed the crime, then you also use a reasonable approach to that person, not by just accosting this person in anyhow or any way you think you want to do that because you want to effect an arrest. It's not supposed to be so. So from the police station, from the police agency rather, I think there is a need for training of these people to the way they approach people that they think committed a crime or a suspect. Now, coming down to the courts, the police are also the one who prosecute the matter at the first stage. Yes. That is the magistrate's court. Yes. Now, I wouldn't want to even continue to buy that idea because some of these police officers know nothing about the law. So you just find them in court, they stand up and they want to start prosecuting the matter, they're representing the state and all of that. But you will later find out that they actually know nothing about the law. So in that wise, I would, actually say that there are lawyers in the police force. So they should be the ones that should be handling that aspect in courts, not just anyhow police officer. So the lawyers should be the ones to take up matters, should be the ones to represent the states, so that there would be normal adjudication process in courts, and not just because now if the police are actually the ones handling the matter from the first stage, and because of that, if they don't know the law, there are lots of delay that happens within just that person's matter. A lot of things happen. Is it the fact that they don't get to bring their prosecution witnesses, and they don't know how to go about it? They just keep telling the courts, giving the court excuses upon excuses, and the courts keep adjourning. So that's another challenge. That's another issue faced within this judiciary system in Nigeria. So the court has like a lot of cases before it, and you don't actually know where to go to because the prosecution or the prosecutor, that's the police officer, keeps adjourning based on some excuses that the judge or the magistrate would want to still give that prosecutor a benefit of doubt. Let's give them a benefit of doubt. Let's give them a benefit of doubt, and they keep adjourning, which causes delay.
Meanwhile, the suspects might be in their custody.
The suspects will definitely be in custody, and the suspects might even be innocent of the crime. So you would see some matters that have taken up to 5, 8 years without nothing going on in court.
So what could you say are the solutions to this? Is it perhaps the re-education of our police officers, or maybe there should be a learning institution designated for the police force to learn the Nigerian legal system, to learn the criminal law and how to go about these cases. What would you describe as
Yes.
the solutions?
Actually, you are actually saying the right thing in your question, because if the police officers are, up for it, that they want to be the ones prosecuting the matter, representing the state in court, then I think that they should actually go on to have this education of the law. They should be sensitized. They should have frequent trainings on how to, approach the court, on how to go on in a case or in a matter in court. So it would not cause more delay in court. So I think from that stage, because at the initial stage, the case is usually referred to a magistrate court before it is then taken to the High Court. So, but before it is taken to the High Court, there are a lot of things that, go on in the magistrate court before it is then taken to the High Court. So at that moment when it is at the magistrate court, the prosecutor or the police officer is meant to be grounded in whatever he or she is saying in court for that matter.
Now, this is the 21st century. We understand that this is the world of technology where we already have AIs and technological advancement in everything we do. Now, what is the role of the growing technology in the Nigerian legal system? How can we actually leverage on the growing technology in improving the Nigerian judicial system?
Okay, so I'm glad that the judiciary system actually, imbibe on the digital evidence.
Okay.
And like you said, digital is growing, technology is growing, is evolving every day. And now, for the pursuit of justice, the judiciary system, encourages technology. So now this technology are, put in place when you want to gather evidence or you want to gather findings or facts in a given case. Say, for instance, you were not there at the scene of the crime, but when you have, say, a video recording of how the whole thing happened, and then you play it in court as evidence, it is, relevance for that matter and it is admitted. So the old technology, digital thing, it's just to support a given matter or a case in a court, or even to refute any analysis that, or assumption rather, in a given matter or in a court. Now, this reminds me of the offense of rape or defilement. Now, when, there's a victim and there is the offender, now the offender, is alleged of defiling, say, a 3-year-old child or a 4-year-old child. Medical experts would come into place where they would, have a test run on the victim to ensure that, yes, something has happened to this child.
Yes.
And we know that is actually digital. That's actually technology coming into place in that way. Now, it links the offender to the crime. That, they actually found, say, a sperm in this child's body that is linking to the defendant, that is linking to the offender. On the other hand, if there is nothing linking the offender to that scenario, that crime, then, the innocence of this person is established. So the digital evidence technology is actually helping in the judiciary system in Nigeria. It's making us move forward, move ahead. There are even instances where some witnesses might not have the chance to come to court.
Okay.
And the courts can actually go on virtual hearing. I think it all started from COVID-19 period where court had to go on with the cases, and they had to improvise. So with that way, there were, virtual hearing from wherever you are, and even the judge or the magistrate also is on air, having court proceedings.
There is a possibility of having a situation where the judge, the jury, the the defendant, the prosecutor, the lawyer, and
Yeah.
everybody were having the session on social media.
Yeah, yes, there's a possibility of that, but the disadvantage is, Nigerian networks is really bad. So
Yes.
you can just hear hiccups here and there. So it will not have a smooth proceeding at the end of the day. That is why it is always, how will I put it? Just always better for you to have a physical hearing so that, things can go on.
Yeah, I really understand that. Thank you very much for the clarification and how you were able to do justice to all of my questions. Now, our time is fast spent and, I would have to wrap up the program. But before we go, do you have anything you would like to say to the audience? Maybe there is an advice you've always wanted to put out to the audience about criminal law, about the crime in Nigeria, about understanding their rights and, the judicial system of Nigeria. Let's just hear it. Let's hear that.
Okay, so like we said earlier that nobody should be ignorant of the law.
True.
Or ignorance of the law is not an excuse. Now, irrespective of you find yourself at the police custody, take for instance, and you are confused, you don't know what to do at that moment, at that time. Definitely, you see there's this apprehension of fear already around you, so you wouldn't know what to do at that time. But the Constitution has said, has provided that there's a right to remain silent, until you have your legal counsel that would put you through. So at that initial moment, just remain silent. Do not write a statement, any statement. Do not be forced to even write the statement, and hold on till you have a legal counsel. So now your lawyer will put you through regarding what to say and what not to say, in the sense that there are so lot of people out there that are incarcerated at the custody, correctional centers, facility centers, and they've been there for long without no representation, legal representation. So we ensure that we provide pro bono services to them. We do it for free. We don't collect anything from them. And we ensure that we represent them in court until the final stage they are released.
Thank you very much. There you have it, beautiful audience. You can always remain silent. You have the right to remain silent. If you're in a fix, you probably don't have to say anything. You can always wait for your legal counselor. Don't write a statement and don't say anything that would further implicate you. Thank you very much, Barrister Busayo, for your time.
Thank you.
Appreciate your time. Now, this is where we draw the curtain on the program today. To come back next week, same time, same station. I remain Khalid. Bada. Bye for now.
Bye.